Hi, welcome back to La Belle Vie. So, Sarah Boone update. Eve before her hearing tomorrow on September 8th. So, Sarah has written two new letters to the court. The first was on August 26th, written to Judge Wooten, and the second one was on August 30, which was written to the Clerk of Court. Now, you'll recall that Mr. Bankowitz has filed a motion to withdraw as her attorney. He filed that motion on August 22nd. So we're going to go ahead and go through these letters really quickly. One's fairly long. The one to Judge Wooten is very long, but we'll go ahead and get to them now. Okay, so here we go. First is the August 26th letter, and you'll see it's written to Judge Wooten. And then she says basically, Judge Wooten, how do you feel about your attorney withdrawing? During an attempted video visit by a misrepresented shifty reporter, this is how I was made aware of my attorney, Frank J. Bankowitz, cowardly and for the second time trying to ungracefully bow out of my case. Mr. Johnson, Mr. Matt Johnson. And I looked up who this is. This is a journalist from Court TV. So now she's saying, Mr. Matt Johnson, please honor the integrity and ethics of a real reporter and not camouflage yourself as my friend in order to push your way through the rules and regulations of the correctional facility. Professional is also an option when scheduling, but clearly does not pertain to you. Just don't schedule at all, as I have nothing to report to you or Court TV altogether. You're not even a real news channel and only add to the confusion and hysterics wrongfully, illegally, and inappropriately concocted in my case. Do not contact. Wow. I think I saw it was on Court TV recently in the past month. I think there was a Court TV journalist that actually was able to go into Sarah's old apartment. And I think, if I remember correctly, I don't think the new tenants even knew about what had gone on there. But I'm wondering if it's the same guy. Anyway, she's not happy with Mr. Matt Johnson. From my perspective, am I surprised my attorney is trying yet again to give up completely? No. Is it a blessing? Yes. Well, I think that's probably mutual. I think they both feel this way about each other at this point. Let's be honest, Frank J. Bankowitz is a dud of an attorney. He is unprofessional, hides, lies, and is disrespectful. I had a feeling when other attorneys spoke about him, winced, sighed, or rolled eyes, saying they have some of his clients. And after finding his 3 public reprimands, I announced to the court, and which he said pissed him off, being the reason for his first attempted withdraw. That's weird. Withdraw. This was going to be an adventure. Oh, that's interesting. But nonetheless, hoped for the best. Unfortunately, I seem to have gotten the worst. Thankfully, there are many other professional and scrupulous, valiant attorneys still available, and hopefully after all my previous letters and 6 withdrawals to date, not by my choice, Judge Wooten, you will remove the blindfold this time when throwing your darts of justice at the remember everyone has constitutional rights and should be treated fairly dartboard. And you wear glasses, so let's go for the bullseye. Oh my gosh. I don't get why she talks to the judge this way. I get she's frustrated, but you don't want to talk to the judge this way. Anyway, please, thank you in advance for hopefully caring this time. Also, if you are insistent on continuing to be my judge, I don't think, okay, that's not up for debate. As revolution is supposed to be every 2 years, I'm ongoing 4 now. What that means. And you've stated to me in your courtroom previously, I have not, because I ask not, may you please observe and act independently as a judge and utilize your judicial authority to judicially maintain forward direction of proper, lawful, ethical treatment and respect of the client in any case. Effective communication between all parties, especially the client and attorney, is being made, productive, regular progress is being achieved, and all around fairness and in every aspect is constant. Aren't you tired of getting my letters, always asking about the same questions, concerns, and drab information? Please do not ignore and avoid what I have to say any longer, as I'm sure the taxpayers are unapproving of their tax dollars, mine too, being wasted for all my attorneys. You keep blundering. Oh my gosh. It took almost 14 months before my I told you so moment with Bankowitz and all my other attorneys, 42 months total. What is she trying to say? It took almost 14 months before my I told you so moment with Bankowitz. Huh. Please also see finally the absolute unfairness, fabrications, impediments, illegalities, and dysfunctions ongoing in my case, and how truly unmistakably ransacked by the justice system and perverted by the whole world my entire case has been and become. Add yourself also to the mayhem, hype, and added difficulties. Huh, it's kind of funny. I just used the word mayhem in the video I posted today on the Murdaugh trial. Oh my gosh. Okay. I have an unfair opportunity in everything with all the predisposed, non permissive, illegally distributed, case altering sensitive information and details spread globally for everyone's viewing except me. Oh my gosh, I feel like I say this every time we read a Sarah letter. Sarah does not understand the concept of public records and open courts and open government. The stuff is all publicly available. My hand is known before the cards are even out of the box. There's not a bell anywhere that hasn't already been rung for all to hear. Seeds have been planted, and illegally and unfairly. For the monumental amount of time allowing the world to abuse and devastate my private case information, lack of proper orders, not having an appropriate attorney, and non existence and security and protection of any kind. Was she getting threats? I hadn't heard that. For all said information becoming, oh, she must be talking about she's still talking about her case records being public. For all said information becoming so easily accessible, mutated, and shared without my permission and before my trial, it is unfair and unlawful that a heavily prejudiced, ignorant, incorrect prejudgment has been made as a result. This could have been stopped, lessened, or averted if someone was doing their job correctly. I'm still doing mine by telling you so. I am not wrong. Well, yes, Sarah, you are wrong. Sorry. That's not the way the laws work in Florida. No, still, I believe it all depends on how much money, notoriety, and benefits anyone and everyone can get for themselves. And however, no matter the destruction caused or the ominous, irreparable shadow made along the very lucrative way, a system for all the wrong reasons. As for Bankowitz and his irreconcilable differences, this means I asked again about his phantom phone numbers and any progress occurring since not speaking to him in months and after. I don't know why this printed out this way. So we've got, now we've got a time clock again. 408 days, 58 weeks, plus 9,792 hours of his representation from the date of appointment 7/11/22 to withdraw attempt 8/22/23. With only 6 in-person meetings totaling plus 7 hours, 4 15-minute video visits, and 2 phone numbers given, 0 working, 0 calls answered, 10 letters from me trying to communicate, no response, 8 letters from me to judge, no response, 4 letters from me to my investigate, 4 letters, oh wow, 4 letters from me to my investigator asking him to attempt communication on my behalf to Bankowitz, 5 known attempts by investigator, C82 letter, by himself directly and on my behalf, no response. 9 attempts made by outside sources on my behalf, including phone calls, voicemails, emails, no response. Also, trying to use recycled components in my case. Well, I mean, Sarah, to be fair, work was done on your case that the JAC paid for. There was 2 years of work done, and you don't just get to start over. I mean, so some of the aspects, because he had been doing some of that work, yes, you don't get new discovery and get a new budget every time you get a new lawyer. So I don't know what that's about. But anyway, no discovery, witness list, research orders, instructions, records, depositions, downloads, etc. after 13 months. So that's interesting. I've always wondered what has he been doing on this case. I mean, we know that He apparently had reached out to and been able to get a domestic violence forensic psychologist. But remember, that was what was going to be potentially discussed tomorrow about funding with the JAC. Other than that, though, I mean, I might have to agree with Sarah. I haven't been able to see that anything's happened really beyond that. Of course, we don't have access to that, but nothing but confirmation of his lack of professionalism, principles, disrespect, lies, and not caring. And please note, 11 of the 13 months with no communication, none in any form. The only difference is I want progress, productivity, honestly, respect, and results. If he were such a professional attorney from the beginning and not selling me on his stable of witnesses, historical background, and all of his abundant resources, he wouldn't be still avoiding and cowering behind his now second attempt to withdraw. Clearly, everyone can see anyone not lambuzled in my slides. Oh my gosh, are we talking about the slides again? Oh my gosh. Would be highly unsatisfied with Bankowitz's overall performance as an attorney, see prior data, and no dedication has been made on his part in my case or any productive progress or effort. What time has been put forth solely? The 7 out of 9,792 hours in 13 months. And as I reminded Bankowitz during one of 4 video visits, and him repeatedly telling me how busy he is with all his other murder cases, after again no communication for months, I politely raised my hand to the camera where he could see and said, "Murder case. I am your client also and have been. Okay, that's fair. When do I get to go to trial like all the other clients?" He said he had to think about everything and disconnected. No word since 100 days later, except for the withdrawal I learned about from court TV, not him. Oh, that's juicy. Judge Wooten, with everything I've stated and all my information produced to you in all my previous letters, so you are aware, clearly Bankowitz should not continue being my attorney. I think everyone probably agrees with that at this point. Wouldn't you agree? Clearly, you should have listened and reviewed much earlier when I was trying to communicate to you 10 letters ago just about him. Please listen and include me going forward is my right. Oh, shoot. Okay, guys, hold on. I'm going to pause. I got to fix this real quick. Okay, here we go. With that being said, and because in the past you have stated to me you have other priorities, not allowing me rightful appropriate time to speak in your courtroom when I am allowed permittance to my meetings and I am on your schedule for that day, 4 times going to court with Bankowitz, total times with all other attorneys, 3, 7 times in ongoing 4 years. April 29, first with attorney withdrawal attempt. Okay. Okay, so we're going back with Padilla. So Padilla withdrew, and remember there were 2, the judge had him amend his motion twice, and I think I described that in my prior video. The reason for that is obviously the attorney cannot divulge privileged conversations. So it's not like the attorney could really explain why there are irreconcilable differences. So it's just a way for the court to like make the lawyer come back and cite cases so that the attorney understands, look, you're not just getting out of this for the fun of it. That's kind of how it works, because you can't just say, "Judge, she doesn't agree with my defense strategy," because we can't do that. So so here we got his withdrawals. And then, of course, Mr. Bankowitz's first withdrawal in December. That was weird. It kind of went away. And then we've got some status hearings. And then just more status hearings. I don't know why this is on here. Please grant Frank J. Bankowitz's motion to withdraw as my attorney. That was kind of funny. Like I said, I don't blame her. I, Sarah Boone, permit Judge Wooten to release Frank Bankowitz entirely from my case for obvious aforementioned reasons stated. I will allow withdrawal when it should be termination. We all know it. Me and my hope. Next. Oh, maybe she's saying he should be fired. Okay. In the meantime, of the selection of my next attorney, aim, please. Oh my gosh. And also going forward, please enable and support me in still trying to utilize my constitutional rights and as a still proud citizen of the United States and stop willingly actively allowing the violations of said rights. See previous letter. Please include me. Please listen to what I have to say. No one else does or has. It's my case. Hopefully, futuristically, with a better, more appropriate professional attorney of your choosing, less letters, if any, will be generated, and more time you will have to dedicate to all your priorities you made known to me in the past. Oh my gosh. Please also know, Your Honor, I know I am not priority as you condescendingly and incorrectly stated, not am I making myself out to be or ever have been in anything my entire life. I am a client to my attorney, now seventh in all prior, an inmate to the county jail, and criminal case for your righteous judgment still. Oh my gosh. Clearly, after yet another letter from me and another withdrawal, not by my choice, and 42 uneventful months later, still looking for the starting line, and 7 times more, nothing has been made a priority. Please help Bankowitz swipe the sweat from his brow and inform him he can stop the self-sabotage. He is no longer my attorney. Amen. My perseverance is real, so is my truth. I can't wait to meet the bullseye. Court-appointed, audacious gratitude, Sarah Boone. Important. Please send me a copy of this letter as the court used to consistently, so I have receipt and know it was received and hopefully read. I do not have the resources being in jail still to make this needed copy myself, nor the pen ink to rewrite. Hopefully my next letter will be less involved from all the necessary remedies being made. Also, my attorney is really an attorney. Thank you in advance for the copy, 10 pages, your caring and precious time. I will look for in the mail once the copy has been mailed. Again, so grateful. And that's it. Okay, guys, so that was letter 1. Letter 2, as I mentioned, was written on August 30th, and it was written to the clerk of the court. So I'm going to go ahead and insert that one now. Okay, so here you'll see August 30 to the clerk of courts. Oh, I guess, and Judge Wooten. Clerk of courts, Judge Wooten, anyone. So confused, so tired of the perpetual question marks over my head. As usual, thanks to the ongoing convolution of everything from no communication, no system, not including me, and no care, and I can't ask my attorney because he's trying to withdraw again. I wouldn't get a response anyway. It's funny how the only piece of correspondence via mail I have actually received from Bankowitz is his motion to withdraw as counsel. Oh, I guess she did get it, because remember the letter we just went over a minute ago? It sounded like she hadn't received that correspondence. So anyway, but apparently she found out about it from court TV, which is really crazy. Judge Wooten, please clarify my requested information as follows so I, the defendant in my case, can prepare and plan accordingly. See letter dated 6/29, hand delivered, second copy 7/21. What is going on? This information in question is all I have from an outside source looking at the clerk's website to keep me updated since no one else will. I've tried to dilute some of the question marks, but need you, Judge Wooten, to help me get it correct and begin my preparation. Please clarify and send copies for... Okay, so she looks like she wants copies of the notice of hearing. I guess she just wants docket copies. Why didn't I receive a copy from my attorney? This notice of ex parte, this is basically what was supposed to be argued tomorrow about the funding issue. Is this meeting for the recycled psychologist? Uh-oh. What did she just tell us there? Recycled psychologist? I thought they wanted a new psychologist. That was the point, because JAC was saying, look, you've had your experts and we're opposing this. You don't get to just pick the best, was basically the tenor of that motion. I've got a whole video on it. I'll try to remember to link it up here. But this is interesting. Is the meeting for the recycled psychologist? Was she trying to go back to one of the psychologists that Mr. Padilla had originally retained? Oh, interesting. Notice of hearing. This August 22 is the date that Bankowitz filed his motion to withdraw. Is this for the motion withdraw? Um, and then the motion to withdraw. Why does apparently she wants all sorts of copies. And then here's the Bankowitz motion. Okay, 2 meetings are already scheduled on this day. Well, yeah, I know. I don't know what's happening either, guys. That was my question, right? Because remember, again, as I said, it was supposed to originally be the hearing for the JAC costs, but now we've got Bankowitz noticing up for his motion to withdraw. So stay tuned. I'll be checking in the morning. Why didn't the court send a copy with the status hearing filed the same day? Again, what is going on and when? Well, I mean, a lot of this, I agree, will get fixed, presumably, when she finally has an attorney. I think that there's a working relationship there. I rarely am included in the certificate of service for any document filed or anything else. It should be an automatic inclusion. Please send revised and/or all correct copies of the aforementioned documents so I have for my records, and is the only way I know unless able to find an outside source. Again, receiving copies of notifications, update schedules, everything to all my meetings, conferences should be automatic so I know. It is my right. Please include. Finally, I agree with that, but I'm not sure that some of the things she's mentioning up there are actually documents. A lot of times they're just entries about just entries in the system to indicate there was a hearing. There's not always a document that goes with some of the stuff on the docket. But anyway, but she should receive copies, absolutely, of motions and stuff. Am I really the only one who is trying to figure anything out for and about my case to finally conclude? Shouldn't I, the defendant of all parties in my case, be included overall and receive necessary needed copies? Please clarify everything, Sarah Boone. I think that's the end of it. So there you go, guys. I also don't know what's going to be heard tomorrow at the hearing. We have, like I said, the JAC motion, and we've got Bankowitz's motion to withdraw, both set for hearing on tomorrow. So I'll report back and let everyone know what happened. And again, never a dull moment. Thanks so much for joining, and I hope to see you in my next one.